Good morning. Welcome to our SESCO webinar. I'm Lauren with Bankers Insurance, and presenting today is Jamie Hasty from SESCO Management Consultants. Bankers Insurance has partnered with SESCO for many years, and since 1945, SESCO has provided human resource and employee relations consulting throughout the United States. If you're a client of ours, we encourage you to take advantage of your access to SESCO. Just a few housekeeping. This webinar will be recorded and I will share the recording with everyone at the end of the webinar. And we will also have a question and answer. So as you think of them, just place your questions in the chat or the Q&A feature. And with that, I'll turn it over to Jamie Hasty, Vice President of SESCO Management Consultants.
Thank you, Lauren. Good morning, everybody. Happy holidays. It's nice to be back. We do these webinars on a quarterly basis on a variety of topics. And with some of the recent changes with the DOL and the nationwide injunction, it's always a good time, especially at the end of the year, to bring up wage and hour. Wage and hour obviously is very, very complex. And it actually can be your number one financial liability as an organization. SESCO was actually founded by a former wage and hour investigator, as Lauren noted, back in 1945. So we've been doing this quite a lot and for quite a long time. And it is one of the very, very large areas of our business that we focus on with clients nationwide. So a lot of content to cover today. As Lauren noted, please feel free to use the chat feature. I am going to field those at the very end, just because when I'm in presenter mode, I cannot see the chat feature. So once I stop sharing my screen, I'll walk through those. I will make sure that Lauren gets a copy of the PowerPoint and then she can share that with you all subsequent our session today. Okay. So let's jump in. Fun fact, FLSA has been around since 1938. The Department of Labor Wage and Hour Division oversees and enforces the Fair Labor Standards Act. And it's also really, really important to note that each state has its own state regulated and state supported DOL, as well as often their own wage payment regulations. Now, if you're here in Virginia, you may recall a couple years ago, they changed some things up with the exemptions and it caused a big stir in how you calculated overtime and all of these things. So Virginia has reverted back, but also remember that January 1, Virginia minimum wage is increasing. Okay, it's no longer $12. Shoot, I'm not gonna give you the correct number off the top of my head. I should have been prepared for that, but it's at or around $12.34 or 43 cents. There was a percentage increase, but I'll send follow-up information on that. But if you're in Maryland or North Carolina follows federal minimum wage, but other states and even localities, counties have their own designated minimum wage. So you always want to make sure that we're complying with both federal as well as our state regulations, okay? So the intent behind the FLSA was really to make sure that there were baseline standards for minimum wages, maximum hours of work, incentives for overtime, rules on how we deduct, how we handle travel time or deductions from wages and salaries exempt pieces, right? So it's intended to make sure that everybody's being paid fairly, for the time that they are putting in with your organization. On average, there are millions of dollars recouped every year from the Department of Labor Wage and Hour Division. That's typically done through audits, whether that is going to be a complaint-driven audit or a random audit. Typically, DOL will focus on particular industries each year. They have a task force. They know that certain industries yield complex pay situations. For quite frankly, the last few years, it's been very, very heavily focused on healthcare, whether that be home healthcare, long-term care facilities, independent healthcare organizations, There was a few years where the automotive service, whether that be a car dealership and or an independent service shop, have been targeted because of their pay plans and commission structures. But anything can trigger it. And we'll talk a little bit towards the end of our time today what we do when we do get an audit, because that is a very large undertaking and can be very time intensive, quite complex, and can add up in terms of cost very, very quickly. Okay. Common misconception is that safety or OSHA compliance is our number one financial liability, and that is actually incorrect. It is always going to be wage and hour liability. The way that the regulations are written is that if you have back wage liability, or you've been audited before and haven't fixed what you were supposed to fix through that audit, they look back 2 years, sometimes 3 years. Sometimes if they move straight to lawsuit, here in Virginia, they can circumvent the DOL altogether and go through a civil litigation, and you're going to look at 4-year liability. They don't just look at one particular position. They're going to look at all positions, okay? They're also, if you have multi-locations, they will open up that suit or that investigation, that audit, to all of your locations, even if they're in different states, okay? So there is a lot of liability. There's what we call liquidated damages. So for ease of an example, let's say my wage and hour audit yielded a $50,000 back wage liability for the last 2 years. Well, under FLSA, they're going to impute liquidated damages. That automatically makes your back wage liability $100,000. It doubles the penalty. Then they can seek compensatory damages on top of that, interest on top of that, attorney's fees, etc. It adds up. So it will always be your number one liability in terms of money for your business. It's important to note that not everybody is covered under the FLSA. Primarily everybody is, but there are a few exceptions. We have to have what we call enterprise coverage, meaning we have 2 or more employees that are engaged in commerce. They're producing goods for commerce, they're selling, they're working on goods that have been moved or produced across state lines by anybody. You also have to have a gross annual sales volume of goods or services of $500,000 or more, okay? Then we also look at individual coverage. If this person is engaged in either interstate or foreign commerce or producing goods for transportation that go across state lines, including fringe production activities, you're covered. So again, the majority of employers nationwide are covered. There are a few scenarios, typically we see it for religious organizations that may not be covered underneath the FLSA. Now, let's hit some basics. So everybody is entitled to minimum wage. Yes, federal minimum wage is still $7.25. Okay. However, different states have higher thresholds. Everybody has to keep an accurate time record. Now, when I say accurate time record, I mean true and accurate. When did they start? When did they take a break? When did they come back from break? When did they end for the day? Generic timesheets where somebody is saying Monday I worked 8 hours, Tuesday 8, Wednesday 7, Thursday, Friday 8, and it's just not showing in and out. That is not going to be what the DOL considers to be true and accurate. There is no specific requirement on how that time, or what format rather, that time should be recorded. Some people still use handwritten timesheets. That's perfectly fine. Some people do electronic timekeeping systems or logins for their employee, thumbprints, all the things, right? So you have a variety of ways of tracking it. Heck, it could be written on a napkin as long as the employee signs it and says this is true and accurate, okay? So minimum wage, true and accurate time card, and everybody is entitled to receive 1.5 times their regular rate of pay. And I'm going to talk about what regular rate is, for any hours that exceed 40 in a work week, okay? Unless Everybody's entitled to these things unless they are considered exempt from overtime. I will cover the exemptions here in just a minute because paying somebody on a salary does not mean that they are exempt from overtime, okay? Now, remember that for purposes of overtime, each work week stands alone. Even if you're paying them on a biweekly basis, you cannot average the work weeks together. Meaning, if somebody works 40 and 1 and 35 or 42 and 1 and then 37 and a half or 37 in the second one, but they total 80 hours for the pay period, they're still entitled to the week in which they worked over the 40 hours. They're entitled to that overtime, okay? So each work week stands alone for purposes of overtime. Okay, let's talk about the salary threshold. Going back to 2023, and even further, let's go back to 2016, because we've seen some increases over the years. Prior to 2016, the guaranteed salary threshold for somebody that could be potentially considered exempt was only $455 salary per week, okay? Now, in 2016, under a previous administration, DOL tried to increase that to $913 per week. That went into litigation for almost 4 years, 3.5 years. And then they settled it out. And effective January 1, 2020, all of the white collar exemptions, your executive, administrative, computer, professional, all of those things are at a $684 guaranteed per week. Now, again, your state, depending on what state you're operating in, may have a higher salary threshold, okay? So there was a lot that happened towards the fall of 2023 where DOL said, we're going back to the table and we're going to increase the salary amount. If you recall, in July of this year, it increased, right? It increased to $843 per week. Well, with the recent nationwide injunction that was announced right before Thanksgiving, that increase has been wiped out. It was supposed to January 1, then increased to 11/28. Okay. So technically, with this court injunction, they said, DOL, you overexercised your power. You don't have the ability to increase arbitrarily the salary threshold without also taking into consideration duties and other things, right? So you overstepped. We're going to stop you from doing that. Now, is there opportunity in 2025 where they'll go back to the drawing table and either say, look, the July 1 increase to 843 is going to stand? Maybe. They may even increase it again. Who knows? But the reality is, technically, the salary threshold is still at $684 per week, even if you increase people back in July to keep them exempt because we were anticipating this incremental increase under the new regs. All right. So $684 guaranteed, regardless of the number of hours that I work in that week, I am guaranteed that salary. Okay. Also, under the current regulations, you can offset up to 10% of that guaranteed amount with an incentive or a commission. So let's say I have somebody that makes $32,000 a year in salary, but I want to keep them exempt, but I don't want to increase their salary. I want to give them a bonus or a commission at the end of the year to bring them up to the threshold. You can do that. Most people do not, but it is an option under the current regulations. Okay, so here you will see where we kind of noted the proposed regulation. They issued it, you know, back in the fall. They went into litigation. So right now, again, we're still at $684 guaranteed per week. Okay. I just mentioned that paying somebody on a salary basis does not mean that they are exempt from overtime. There is a salary amount. There is a guaranteed salary threshold, And then there are duties and tests that also have to be met. It is an all or nothing approach to wage and hour. If they meet the salary but not the duties, they're non-exempt. If their duties are there, but they don't meet the salary, they're non-exempt. Okay. So you can't just put somebody on salary and think we're good to go. Here are what we call our white collar exemptions from overtime. Okay, these are full exemptions from overtime. That means if I meet the salary and the duties tests of either executive, administrative, professional, computer, I do not have to keep a time card, technically. Now, if you want everybody in your organization to keep a time record because it helps you out with ACA reporting or affordability tests or anything like that, great, you can. But if they truly are exempt, they don't have to, right? So let's dig into each particular exemption. Executive exemption is the easiest one for us to look at. Do I manage a department or a division where I have at least 2 or more full-time employees that report directly to me? Do I have the ability to hire and fire? Am I doing their performance reviews, their discipline, their coaching, their counseling? Am I, checking the quality of their work? I have to be engaged in these management responsibilities of these employees no less than 51% of my work time. Okay. I also have to obviously make $684 guaranteed per week. Now, this exemption is pretty easy to apply in, let's say, mid-sized to large organizations. But what happens when I have a small business where I've got an owner who's pretty active in the day-to-day, and then I have a couple of other quote unquote managers that are perhaps deferring to the owner for decision-making power, for hiring, for firing, all of those things. Those managers are not going to rise to the level of executive exempt in the eyes of wage and hour. Why? Because they're not spending 51% of their work time. They don't have the ability or that high level authority to hire and fire. Okay. Same concept applies to an active working manager. Maybe I have a manager title, but I'm doing the exact same type of work that the people I'm allegedly managing are doing. And I'm more of like a lead or a foreman or, just a supervisor there. Okay. That could also lead us into a potential misclassification. Now, the administrative exemption is the hardest exemption to apply. It is also, per wage and hour, the most commonly misapplied exemption from overtime, right? So administrative exemption applies to those who are doing office, non-manual labor type work. These people may not have direct reports. Maybe they're a one-person controller or a one-person HR department or a one-person office manager. Okay. With the administrative exemption, as the reg is written, you have to be making high-level independent judgments and exercising independent discretion no less than 51% of your work time for matters of significance that directly impact the overall business operations. Okay. Capital expenditures, strategic planning, policy procedure, writing, interpreting, changing, having the authority to write, interpret, and change policy and procedure. Okay. Anything that is considered regular or recurring work, like let's use accounting for an example. While it is, yes, an essential business function, it is routine and repetitive per DOL. You're following processes. There is no decision-making in that. You're putting things in general ledgers where they go. It's following a pre-described process in accordance with GAAP procedures, okay? Although it is an incredibly important business function, DOL says accounting, payables, receivables, general ledger stuff is not administrative exempt type work. Okay. So Administrative exempt gets people in a lot of trouble because, again, we try to put our payroll person on it. We try to put our office manager on it, and they're doing administrative, routine, repetitive type work, and it's not gonna fly in the eyes of DOL. Then we have our learned professional exemption. These are your doctors, your teachers, your lawyers, your nurses, but it's based off of the level of degree education that an individual has. So with learned professional, it has to be an advanced degree in the field of science or learning. Typically, DOL interprets advanced degree as master's level or higher. Okay, master's, doctorate. Definitely not associate level. Occasionally, you can use a 4-year professional degree if it comes with licensure. So let's use registered nurses for an example. RNs with a 4-year degree, because then they also have to take their boards, would be considered professionally exempt, whereas a 2-year RN is considered non-exempt. Okay. With the learned professional exemption, it is on the basis of a salary or fee. Okay, so a flat fee, like a per diem per day, as long as that fee brings them up to at least the $684 guaranteed per week. Okay. Now, computer exemption. These are for programmers, analysts. These are for people that are developing systems. These are not your general IT support folks. These are not your network administrators, people that are handling your website. Okay. Just like with the professional exemption, it is a salary or a fee basis, but it still has to be at or above $684 per week. Okay. So computer exemption, we also see pretty commonly misapplied for people that are setting up laptops or desktops or doing general help desk type work. It's not going to be computer exempt. Outside sales exemption, these are people that are spending the majority of their time, at least 51%, outside the workplace, negotiating sales, obtaining contracts, selling that product or service, knocking on doors, making calls. Inside sales is not going to be exempt, but outside sales potentially could. Again, we have to look at how much time is spent away from their workplace engaging in these activities. Outside sales does not have a salary threshold. Okay. Then we have highly compensated employees. Now, there's a lot of confusion over the highly compensated designation. Okay. Quite frankly, I rarely use this exemption because it's kind of a moot point. And let me tell you why. If I have somebody that is guaranteed $147,000 or more annually, okay, and they're exercising independent discretion and judgment, which is required underneath the administrative exemption or the executive exemption with, management responsibilities, they're already going to be considered exempt under exec or admin, because if they're making over the 35,000 threshold, they're exempt. So yes, you can dually designate somebody as executive or administrative / highly compensated, but you don't really ever need to use this highly compensated exemption. Now, there are a variety of partial exemptions from overtime, depending on your industry. If you are a car dealership, you can use the automotive 13B10 exemption for your salespeople, new and used cars, your parts counter people, your service advisors, your service technicians. If you are a transportation company, and you are, driving trucks that are over a certain weight, and or you're transporting products across state lines, interstate commerce, You might be able to use the motor carrier 13B1 for your drivers, your loaders, your helpers, and those mechanics that work on those trucks, okay? There are farm worker exemptions. There are certain seasonal and recreational. So if you run a fair or an amusement park, there are exemptions from overtime for those folks, okay? Just like with the white collar exemptions, there are certain tests and descriptions that have to be met with these partial exemptions. Now, when I say partial exemption, that only removes our responsibility for overtime. Under a partial exemption, they still have to keep a true and accurate record of time, okay? We also have a retail 7I partial exemption. So maybe I'm not a farm worker, maybe I'm not an automotive service, maybe maybe I'm a pawn shop and I've got my folks on a base plus commission, okay? Because we're selling products. If at least 51% of my total compensation comes from commission and my average hourly rate, including those commissions, total monies earned divided by total clock hours worked, yields at least 1.5 times minimum wage. Okay, now remember the 1088 here in this slide is based off of federal minimum wage. If you are in a state that has a higher minimum wage, so right now Virginia is still 12 times 1.5 is $18 an hour. Okay. So as long as my average hourly rate, total monies earned divided by total clock hours, is over $18 an hour, I might be able to be partially exempt under retail 7I. Okay. But what if I have somebody on a salary? Okay. Let's use the example below. Let's say I pay somebody $600 a week salary, which ends up being $2,400 a month. I need at least another $2,400 a month in that month in commission to satisfy the 50-50 test. Okay. So just like with the full exemptions, these tests and duties under partial retail 7I, it's an all or nothing. They have to hit at least 51% and yield 1.5 times minimum wage for all hours worked. So what do we want to do? It is always best practice to have a wage and hour audit conducted by somebody like a SESCO who is well versed in wage and hour accounting practices and employment regulations, and or an employment attorney to review your payroll. You want to look at who's on salary, who's not on salary, who's hourly plus commission, who's hourly plus a bonus, how many hours are they working? And we want to make sure that folks are appropriately classified as exempt, non-exempt. If you have a misclassification, which is very common, we need to make adjustments to negate your liability. That may also include doing a 2-year look back to see how much money we should have paid them in overtime and make them whole for that 2-year period. Okay. There are other ways to play with misclassifications or to negate our back wage liability. If they're working 41 hours or 42 hours, is there an opportunity where we can manage those hours down consistently? Okay. However, if it's not, then there are alternatives to putting somebody on a fluctuating work week or straight time method of calculation where they can stay on salary, but we're paying the half time of overtime. Or if we want to keep them, salary plus commission, and we know that they're working overtime, then we just need to put in parameters to appropriately calculate the additional overtime owed on the commission. Okay. There are always options. It is not something that cannot be fixed. We see it day in and day out. So let's talk about alternative pay plans. I do want to be very, very specific that fluctuating work week is an available method of payment. It is approved by the Wage and Hour Division. However, this is not SESCO or Jamie at SESCO endorsing you using fluctuating work week. Okay. There are a lot of intricacies with this type of pay plan that, if not done correctly, can open you up to significant liability. Yes, it is a cost savings in terms of overtime by doing a straight time calculation versus a traditional hourly times 1.5. Okay. However, again, I see a lot of misuse of fluctuating work week or confusion on it. So I am not endorsing that you use this, okay? But it is an option. It is approved by DOL to be used. What FWW is basically saying, I'm guaranteeing your salary for all of your hours worked, okay? And then I'm going to pay you half time, 0.5, for any hours that exceed 40 per week. Let's use an example. These are low numbers, so just play the game with me. Let's say I have somebody on a weekly salary of $679 per week. Okay. Remember, overtime is calculated at 1.5 times the regular rate of pay. Well, under FWW, that salary covers all hours worked, the 45 hours that week. But I still owe, that's the 1.5 times, right? But I still owe the 0.5 of the 1.5 on the hours that exceed 40 in that week. So what you do is you take the weekly salary, you divide it by the total hours that they worked that week, and you get what we call a regular rate of pay. Okay. So in this example, that regular rate is $15.08, but I still owe them the 0.5. So I take 15.08 times 0.5 to get $7.54. I use the $7.54 times the 5 hours of overtime that I additionally owe, and I pay them out an additional $38.02. Now, what's important to note is not all of your payroll providers will do this correctly. They may not allow, per your contract, to do the straight time calculation. Okay, so don't just make an assumption that your payroll provider is going to do it right, whether that is FWW or calculating the additional overtime owed on a commission or a bonus for an hourly overtime eligible person. If you don't want to do the manual calculation, DOL does have a coefficient table, which basically is broken down into eighths, tenths, and quarter hours, and you can kind of scroll and find 42.5 down, and you get your coefficient. So in the previous example, we had 45 flat hours. So I would have used 0.056 times the 679 to get the exact amount owed in the additional overtime. Okay. Now, with FWW, there must be a letter of understanding signed by both you and the employee. They need to understand how this pay plan works. You cannot move people in and out of this pay plan or start changing salaries to, every single week to back off of what you owe them in overtime. That is misuse of the plan. Okay. The downside to FWW is the more hours they work, the lower their regular rate of pay becomes, which means the lower their overtime rate becomes, right? So in 1 week, if I've got 42 hours, I might be getting overtime at $8 an hour. And the next week I work 50 hours, which means my overtime rate really drops down to like $3.50. Okay. So it's not for everybody. It doesn't work in specific industries. If you are going to consider this type of pay plan, you really, really need to work with an attorney or a consulting firm to review and make sure that this is the proper pay plan for your business. Okay. And also that you understand how to implement and execute it. Okay. So What do we want to do? Always assess your liability. It's best practice to have an audit at least annually at, no more than every other year, right? Look at who's working overtime, how much overtime, where can we manage things down, what alternative pay plans can we make, what are the budget effects of these? If I have somebody that I thought was exempt, but now is non-exempt and I need to pay the additional overtime, it's a lot. So that's why you really want to partner with somebody that understands wage and hour. So if you are a retainer client of SESCO, depending on the level of retainer, that assessment is included. If you're on a telephone only retainer, it is not, but there are options, whether that be through a retainer or billable service, if that audit is of interest there, right? So we get questions a lot about, can I keep paying somebody that's misclassified on a salary? Yeah, you absolutely can. But we're still going to have to pay overtime, right? And we can do that through, the straight time method of calculation. Also, we need to be mindful of hidden overtime. Even if the position is scheduled for less than 40 hours, you need to make sure that they are not exceeding those 40 hours. Answering emails or doing work at home after hours is technically considered compensable time and needs to be included in their time record, right? So, there's options there for you. Friendly reminder that no employer is required to guarantee overtime. In your employee handbook, you should have a statement in there that overtime must be authorized by that supervisor in the week in which the overtime needs to be worked. Now, we often see situations where an employee works overtime, supervisor did not authorize it or know about it, and payroll's saying, hey, Mary, hey, John, why does this person have 4 hours of overtime this week? And the manager is going to get frustrated and say, well, I don't want to pay it because I didn't approve it. Well, too bad, so sad. You have to pay it. If they are working unauthorized overtime, it is a performance management issue that needs to be addressed through your progressive discipline. Okay. We are not also required to pay an employee more in compensation as a non-exempt employee than what we would pay them as an exempt employee. All right. We often also get questions on, can I back into an hourly rate? Let's say I have somebody on salary that's misclassified. Can I back them down an hourly rate, knowing that I'm going to have to pay overtime, and kind of run that calculation to make them, in essence, flush for the year, right? They're getting the same amount in annual wages based off of the average overtime that they're going to work and that we're going to pay plus the hourly rate. So you can back yourself into an hourly rate, but again, it needs to be done correctly. Also remember, when we have misclassification, somebody that's been on salary or somebody that wants to stay on salary and doesn't want to keep a time record, and we feel like, hey, having them on salary is what the employee wants. We're doing them a favor. They've got that consistency there. And listen, those are all good intentions. However, remember that employees cannot waive their rights to overtime. So even if the employee asks to stay on salary and we know that they're really non-exempt due overtime, or they say, I don't want the overtime, don't pay it to me, we still have to comply with the law. Sometimes we run into morale and perception issues when those changes do occur, where people get frustrated because now I have to keep a time card. Well, that makes me feel like I'm no longer a true manager because I have to keep a time card. So there is a communication strategy that needs to be deployed when we are, making some changes with classifications. You also may have to do some training on the timekeeping system, or communicate expectations on what they're going to have to do in terms of complying with meal or rest break requirements. Federal law does not require a break period at all, but there are rules on how long that period may be if you plan to deduct it from total hours worked, okay? We also need to look at deductions for partial day absences or restrictions on working after hours or travel time and all of those things. So there's a lot that plays into wage and hour. So again, plan now. Again, we're at the end of the year. It's always a great time to review things, to prep for any changes that need to occur January 1. And, these are just some suggestions there with staffing, scheduling, challenging bonus or commission structures, delaying future compensation increases to absorb additional cost. Again, these are not things that you have to do, but these are just some strategies that we often review during the audit process. I do want to cover some common FLSA violations and traps that I see, whether it's when I'm doing a HR compliance assessment for my retainer clients, or I'm representing clients with the Department of Labor and their wage and hour audit, because these little things can add up. So obviously, trap number one, misclassification of a non-exempt employee as an exempt. We've already covered those in detail, so I won't, be repetitive there. Trap number two, I just mentioned this, employees cannot waive their rights. Even if they say, I don't want that overtime, or I want to stay on salary, I like salary better. If you know that they're entitled to overtime, you're also assuming the risk involved if we're not making appropriate changes and knowing that you have a 2-year back wage liability there. Trap number three is not understanding what is considered hours worked. Easy thing, easiest way to look at it. If it is for the benefit of the employer, emails, calls, pre-employment documentation, pre-employment training, orientation time, all of that is compensable time, okay? Let's talk a little bit about break time. Under FLSA, it is what we call a bona fide meal period, okay? And I'm not sure where everybody is located, but let's just use Virginia for example. There is no requirement in Virginia to provide a break whatsoever. There is no such thing in federal and or Virginia law that says if you work 6 hours, you have to get a 30-hour or 30-minute break. If you work 8 hours, you get a 1-hour break. That's not a thing, okay? If you are giving multiple breaks, 15 minutes in the morning, 15 minutes in the afternoon, and a 30 for lunch, that's solely based on your company policy, okay? It is not required under federal or state law. Now, if I'm looking at other states like New York, California, Chicago, yeah, there are state regulations that require, an X number of break after X number of hours worked. Okay, so again, this is where we have to comply with both state and federal. But if I am providing a break time and I don't want to pay for that break time under federal law as a bona fide meal period, I need to be free and relieved from duty for no less than 30 minutes. Okay. Where do people get in trouble with this? Well, they're either A, doing auto deductions in their timekeeping systems for lunches, and not keeping up with somebody that may not take a lunch and not adding that time back in. Or maybe somebody's clocking out for 18 minutes, but because we're short-staffed that day, they eat their lunch at their desk and jump right back into it. Or they're doing emails and eating at the same time, but I'm still deducting that 30 minutes or that hour. That's not correct. If it is less than 30 minutes and they're still doing work, or their 30 minutes is interrupted where they're coming back to work and not free and relieved from duty, it is considered compensable time. That's why it's so important that your managers, supervisors, whoever is in charge of reviewing those time cards every week before payroll processes them, make sure and is looking for what we call short meal periods. Now, DOL will give you a cushion. So technically, even though the reg says 30, 25 is your minimum threshold. If it's less than 25 minutes, it needs to be added back into the total time for that day. Also, travel time. Okay, there are very, very specific guidelines on how we handle travel time. From my home to the office or to my job site is not considered compensable time. But what happens if I'm leaving the office and going to another location to, pick up documents or deliver something to another location or to another manager, and I'm an hourly employee? That is considered travel time and is compensable. Between locations is paid time. Okay. When I leave the office for the day and I go home, it is not compensable. Okay. That's part of the Portal to Portal Act, and there are very, very specific rules. There are also rules for people that travel out of town for meetings and training and how that works and what time is really considered training time, whether it's overnight, all in one day's travel and or overnight away from travel. What if it's travel on the weekend? So travel time gets quite complex. If you are requiring them to attend a meeting and or a training, you have to pay them for that. If you are making a training optional, but it is highly encouraged, you need to pay them for it. Okay. So hours worked can creep up. So again, just general guidelines on portal to portal. Anything that's all in a day's work. Say I leave my house, I go to the office, meet my coworkers. We drive down to Roanoke for an all-day training conference. We leave Roanoke at 6. We don't get back to the Richmond area until 8 o'clock at night. Well, because we met at the office and we left and we came back to the office from, let's say I left the office at 7 o'clock in the morning. 7 o'clock to when we got back to the office at 8 p.m. is all paid time. Okay, because it's travel, that's all in a day's work. But travel away from home in our community, you follow their normal schedule for that day. If I'm normally scheduled between 8 to 4, I'm only going to be paid from 8 to 4 on that day that I'm at a conference at the Hilton down the road. Okay. So there are very specific rules there. Also, if attendance for a meeting or a training program is outside of their regular working hours, you're probably going to have to pay for it. If it's voluntary, you may or may not have to pay for it. Again, we have to look at the specifics of those particular situations. Holidays and vacations do not count for purposes of overtime. Uniforms, you have to be careful on incidental activities with that as well in terms of requiring them to be paid for or deducted from wages. Okay. So trap number 3, also we see working lunches. I mentioned that under break times, pre-work, maybe I'm coming in and doing some work before I'm technically allowed to clock in. Technically that pre-work is considered compensable. Same concept with homework. If I'm doing work from home in the evenings or on the weekends, it needs to be included in my time. And I already mentioned unauthorized overtime as well. Trap number 4 is not calculating the regular rate properly. Common misconception is that overtime is calculated on my hourly rate of pay, and that is not correct. Okay. Regular rate is defined as total monies earned divided by total hours worked. So if I'm giving them a non-discretionary bonus is something that is tied to a standard that they can meet. Production, safety, attendance, knowing that if I hit this goal, I'm going to get this $100 or $500 commission or a bonus. Well, those additional monies have to be included in the total monies earned to get the regular rate of pay. Okay. Averaging work weeks, I mentioned earlier. Each work week stands alone for purposes of overtime. Now, let's talk about comp time. common misconception is that comp time is considered paid time off. It is not. Okay. Comp time is when I'm going to say, hey, Doug, you worked 50 hours this week, but instead of me paying you the 10 hours of overtime this week that you're entitled to and that I owe you, I'm going to add 10 hours of time into your PTO bank. You can use it later. Okay. Comp time is illegal for all private employers. Private employers. If you are a public sector entity, state, local government, a school system, federal employee, what have you, comp time is fine. Okay. State and government entities are allowed to use comp time, but private sector employees are not. Okay. That's a big one. Also, if I have somebody that is either hourly or salaried non-exempt and they are receiving a bonus, a spiff, or a commission, those items are subject to the overtime calculation. Whether it's on a weekly bonus, a month end, or a quarterly bonus, you have to pay the additional overtime on the bonus because, again, we're talking about regular rate of pay, not hourly rate. Similar to the calculation with fluctuating work week, you are using the coefficient table for computing the extra halftime, the 0.5 on the bonus, okay? You only have to look at the weeks in which they actually worked overtime. So if I earned a bonus in December as an hourly employee, but I didn't work over 40 in any week in December, you don't have to worry about paying the additional monies. But if I worked 1 week of overtime in the month of December, then I have to take that total bonus divided out by the weeks in which, we have in December, which is 4, and take that, $125 that would have been allocated to that week for that bonus, and then use the coefficient table to calculate the extra halftime. All right. So here's an example. Let's say we have somebody that makes $20 an hour, okay? And I'm using a straight time calculation, meaning I'm paying them the $20 for all hours that they work, and then I'm paying the additional overtime premium on the 10 hours. So I owe them $1,000 for the 50 hours, then I owe them an additional $10 times the 10 hours that they work overtime. And I also am giving them a $50 bonus. So my payroll person is going to cut them a check for $11.50. That's the incorrect calculation. What needs to occur is you do the straight time calculation of $1,000, then you add in the bonus. So their total pre-overtime amount is $1,050. And then I get the regular rate, which actually is $21, not $20 an hour. And then I do the halftime calculation. So my 10 hours of overtime is calculated at $10.50 an hour, which means I owe them $105. So in this particular example, we shorted them by $5 that week by doing it incorrectly. Here's another example. Okay. Regular rate with a commission. It's the same concept. You've got to include the bonus or commission in the overtime calculation for somebody that is entitled to earn overtime. Your payroll company will not do this for you unless you have asked for it and made sure that they are flagging it and paying it correctly. Now, there are some things that we can obviously exclude from the regular rate. Any sort of discretionary bonus. Maybe I decide it's the holidays, we had a really, really great year, and I, at random, am just going to start handing out additional monies to folks. There's no rhyme or reason to it. They don't expect it. It's not tied to any sort of standard or goal that we have hit. Fine. Doesn't have to be included in the regular rate. Okay. Also, vacation, holiday, illness, sick leave, vacation, those sorts of things are not included in the regular rate. Okay. So these things can be excluded. Trap number 5 is making improper pay deductions. You cannot drop an employee below minimum wage for all hours that they work. Okay. The only exception to that rule is going to be if I have a child support garnishment or a court-ordered tax lien. Okay. Then I can drop them below minimum wage. But if it's for, loans or damage to equipment or, uniforms or that sort of thing, that deduction cannot bring them below. What I would also strongly encourage is to, number one, not do employee pay loans where you have to worry about getting the money back. But if you are going to give an employee a loan, let's say somebody's short or they need money to repair their vehicle and you're a service shop and you're going to let them, quote unquote, charge it to a house account. Do not call it a loan. Call it a wage advancement, because if I advance monies in writing, it's called an advancement. I can take it back in totality without having to worry about minimum wage and having to worry about consecutive wage deduction signed authorizations. Okay, they still have to sign that, hey, it's advanced, I'm going to take it back in full. But then you don't have to worry about deducting, $50 for the next 10 pay periods. So be mindful of pay deductions. Also, DOL is very specific. Anything that is incredibly generic, like a checklist in your orientation packet that says, I give you authorization to deduct for uniforms, damage, coffee, you name it, and it doesn't specifically say what amount is coming out each week or how often, that's not going to work for a deduction authorization. They need to see exactly that this employee has voluntarily agreed to have these things deducted. How much is it? How often is it coming out? Okay. Trap number 6. Please, please, please challenge any sort of 1099s that you may have floating around in your organization. I think we talked about it earlier this year. The IRS, DOL have been actively pursuing misclassifications. DOL did change their guidelines for who can be considered an independent contractor. There are 3 different compliance aspects that you have to look at. The IRS has their own test. It's called a 20-factor test. For a 1099. Then you have obviously Department of Labor, their own definition and 6 factors that have to be explored to determine 1099 status. And that can open us up to overtime liability, back wage liability, etc. There's tax liability, unemployment liability, workers' comp liability. And then you also have your state ABC tests. Okay. So 1099s are still a big thing that they look at. Friendly reminder on child labor. 14 is the minimum age for employment outside of school hours. Obviously limited periods of time each day, but 15 really is your basic minimum age. 16 years old, they can be employed in any occupation other than a non-agricultural hazard. 18 years for employment in non-agricultural hazardous occupations. Also, even though DOL oversees child labor, please remember that OSHA and or your state OSHA compliance aspect is going to have other rules for what minors can and cannot do, okay? Even if it is your own child. So be mindful of that, because you may have not only child labor provisions, but also safety provisions you need to be mindful of. Just some employment standards for 15, 14-year-olds. They have very, very limited times that they can work, how many they can work in a week on non-school days. They can only work over 40 and non-school weeks, okay? And it can't interfere with their school health or well-being. Also, wage and hour does require us to keep a lot of records. So this 13-point list is just records that are enforced by wage and hour. Their name, address, their gender, their date of birth if they're under 19 years of age, their rate of pay, their base salary per week, total hours that they work, overtime earnings, so on and so forth. You need to keep, at least for 3 years, all payroll records, all age certificates, all pay plans, any sort of employee contracts, all timesheets, all commission sheets, records of bonuses, commissions, or any sort of deductions from wages of employees. And at least for 2 years, you need to keep all time schedules, all orders, shipping, and billing records. This is required by the Wage and Hour Division. Also, from an age discrimination standpoint, friendly reminder, job applications or resumes that you have received must be maintained for at least 12 months after receipt. That applies to applicants as well. Because if somebody alleges age discrimination, we need to be able to pull out and see, applications, resumes, all of that. Okay. You also are going to need to keep good notes on why somebody was hired, why somebody was not hired, promotions, demotions, selection for training, all of these things to comply with age discrimination, which is also part of the Wage and Hour Division. Okay. Also, you want to keep copies of any sort of job postings, promotions, training programs, benefit programs, such as retirement, pension, insurance to comply with your 5500s. All right, all of these things are part of our requirement as a whole and in HR. So I mentioned earlier, what happens if we get audited or we are found to have not complied fully with the FLSA? Obviously, there are methods for recovering those unpaid wages. The division is going to do calculations and look at back wages. If it is a blatant disregard of compliance for the FLSA, they will take you straight into litigation. Okay. They will always impute liquidated damages. The only time they did not impute liquidated damages was during COVID. You may be sued for back pay, additional sum of money, reinstatement of job, all of these things, and it adds up quite quickly, right? So what happens if we actually do get an investigation? You've got a few options. First and foremost, you could decide you want to handle it on your own. I wouldn't advise such just because of the complexity of wage and hour. And also, if you are not very well versed in wage and hour, not speaking their language or knowing specific rules or case studies or having access to those things to help defend or negotiate or negate down the liability can work against you. Okay. That's why we always suggest using a consulting firm and or employment attorney to represent you as the agent of record during an investigation. But what causes it? It's either going to be a random audit, which they do occur, or it's going to be a complaint driven. It could be a former employee, it could be a current employee, it could be a friend of either one of those classifications of individuals. Okay. It is very serious business. We need to play nice with the wage and hour investigator. They have a badge and they can make our lives very, very difficult if we are not cooperating. Yes, we can stall them a little bit. Yes, we can ask for extensions. We can, navigate that, but you can't refuse to cooperate in an investigation. Typically, you're going to be notified one of two ways. You will either get a letter through the mail that says you've been selected for an audit. Here's your investigator's name. They're going to arrive on site at this date at this time. And you need to have these 11 items pulled ready to go. Typically, they're going to require you to upload those items into the portal, but they're going to give you a heads up on them. Or, quite frankly, they show up. Sometimes you don't get a heads up. It's not uncommon, especially if it's a random, where that auditor will be driving down the road and just pull into a business and say, hey, I'm Jamie Hasty with the Wage and Hour Division, flash their badge and say, I need to speak to somebody and look at your payroll records. They have the authority to do that. They have the authority to subpoena anything and everything that they want. Okay, they are a federal officer at that point in time. So Things that they are looking for, typically minimum wage, overtime, misclassification, hours that have been worked that have not properly been paid and or recorded, not paying additional overtime on bonuses or commissions if it's supposed to be paid. They're looking for misclassification of independent contractors, child labor provisions, age discrimination. They're also looking at payroll deductions. Now, remember, if this is complaint driven, they've already gotten the employees' side of things. They've already had conversations with the employees. They already know what they're looking for. Some investigators are going to go through all of these liability areas, whereas others might only focus their efforts on what the actual complaint is surrounding. Okay. It is luck of the draw. That's why you should be having an annual compliance assessment. Okay. So typically when we get an investigation, one of the things that I'm going to ask you is, has anybody recently complained about their pay or doesn't understand their pay plan? Have you let somebody go recently that put up a stink or felt like you owed them additional money? That's typically where I'm going to start and look. And also we're going to talk about your particular industry, your pay structures. I'm going to dig into exemptions first and make sure that we don't have any liability there. Why? Because I need to start working on a defense and know how to navigate them to focus on certain areas and hopefully not focus on other areas that may, creep up in that review. So always before the investigator arrives, reach out to a professional, get them on board as your agent of record. Yes, it is going to be expensive. I will not lie to you about that. However, if you have somebody that understands, they can negotiate down, they can negate down, they can work with that investigator to get things done. One very huge investigation I did 2 years ago with a group up out of Connecticut, but they had 30 other locations between Maine, Vermont, and a few other surrounding states. Actually, we were able to negotiate it down an additional $500,000. They paid out a lot, don't get me wrong, because they had some significant back wage liability, but because of certain industry practices and negotiation on breaks and other ways, a good skilled wage and hour consultant or an attorney is going to be able to negotiate down that bottom line figure. Okay. And so I was able to save them $500,000 in that particular investigation. The other thing is you have to have a game plan. We need to know who the players are. We need to communicate and instruct key people that they should fully cooperate and be honest with that investigator. Here's what the investigator does. They are going to interview your employees, former employees, current employees, managers, non-management personnel. Okay. We cannot coerce, we cannot threaten, we cannot retaliate against those people for whatever they may say in those meetings. You also cannot participate in those meetings of anyone that is not considered a manager. And even if you are participating in the manager interview with the investigator, you can't say a word. You can only sit there and listen. Okay. There's a lot of documentation that has to be pulled, right? So you work with your agent of record to get that, to sort, to make sure we're not turning over anything that is unnecessary. We also need to coach you on how to respond to questions. Typically, if you've engaged an agent of record, they're doing all the communications. But if you decide to go it on your own, sometimes people get nervous. Some people voluntarily provide information that actually is not helpful and can work against you in an investigation. So, you never want to give them anything more than what they have asked or answer anything more than the exact question in front of you. During the investigation, obviously, we always want to check credentials, notify whoever is in senior leadership they are there, we're meeting with them. We want to be kind, courteous, pleasant. the more cooperative and kind and respectful we are to the investigator, the more respect we get back on our end as well, okay? With employee interviews, they may say, I need to interview 20 employees. Now, typically what I'm going to do is say, in order to best support you, would it be agreeable for me to provide you with a name of 20 employees and contact information that you could speak with? Why? Because then that allows me to drive who they actually talk to, right? I'm going to pick my good employees. I'm going to pick the employees that I know are not disgruntled or frustrated or that will do well in an interview, okay? Sometimes an investigator will not allow for that. Most of the time they will. Okay. Also, those interviews can be scheduled at our discretion. We don't want to have the investigator walking around our place of business disrupting operations, right? So the timing of that should be a collaborative effort to make sure, yes, we're cooperating with the interviews, but we're not completely disrupting everything. The investigator is going to do their number crunching. Your attorney or your consultant is going to do theirs. Those numbers need to match. If there is a difference there, that's where the negotiations start happening, right? Your consultant may pick up on stuff that the investigator does not look at or care to look at, but we know it's still not right. So those are things that your consultant will note that you need to fix and say, congratulations, you're lucky they didn't ding you on it. Okay. But what we don't do is we never agree without doing our own calculation. Never take the investigator's numbers right off the bat. Why? Because everything is negotiable. But also their numbers could be wrong. It's not uncommon. It happens all the time. Okay. So before we agree to pay back wages, you work with whoever's representing you to check their numbers against our numbers, dwindle that down to whatever the final numbers are. We go back to the table. We say, hey, we don't agree with this, and here's why. Here's case law to support it, et cetera, et cetera. And then we finally get our settlement docs. Now, once everybody is in agreement with what those true final numbers are, then there's a lot of paperwork. You are signing documents that basically say, yes, I was in violation. Yes, I owe these 30 employees back wages, and you have to itemize the amount for every single 30 employees. You've got to cut in 30 individual checks. You have to do your Form 58, which goes with the check. That's important. Not all investigators are going to allow you to issue a Form 58. Your consultant and your attorney are going to ask for it. But if you're doing it on your own, you wouldn't know to ask for the Form 58. The Form 58, basically, when that employee takes that money and cashes that check, they need to sign it, and it comes back, and it relieves us from the employee's ability to sue us in civil court. So, again, intricacies of wage and hour piece. Then we're going to look at penalties for violation. If you have been audited before and we still have issues, we're going to try to negate to the best of our ability compensatory damages. If you've been audited and had a clean audit and they didn't catch it, and now they're catching something that was practiced, that was being done during the last audit, then I'm going to argue against liquidated damages. There is a good faith defense there. I've done it successfully in a few cases. It's hard to do, but again, it's based on the facts and circumstances of your organization. So overall, have good policies and procedures. Make sure your handbook is updated. You have good policy on timekeeping, that I can't clock in or out for other employees. Your managers are trained on reviewing time cards, correctly calculating time cards. What happens if I miss a punch and editing a punch? In a perfect world, I want the employee to sign their time card. I want the manager to also sign that. But also the review of time cards and any sort of adjustments based off of the schedule or missed punches or what have you needs to happen before payroll processes that time. Okay. There are rounding policies that you can look at depending on what timekeeping system structure you have, whether it's eighths, tenths, those sorts of things. We want to make sure that the rounding is calculated correctly. do your audit, have good policy and enforcement of breaks, lunches, after hours work, so on and so forth. Now, I threw a lot at you in a very, very short amount of time. So what I'd like to do is open it up to Q&A there. I'm going to start with a Q&A box before I go to the chat feature, okay? The first question is, what if you do find that a contract worker was misclassified? Great question. If we have somebody that is on a 1099 that truly should be a W-2, you simply move them to a W-2. Okay. You can either cross your fingers and hope that we get out of the 2-year period moving forward without any issue, or you can look back and in essence calculate their time or try to recreate their time for the last 2 years or however long they've been with you, and pay them out appropriately for minimum wage, overtime, so on and so forth, which may require you to collaborate with an accountant on taxes owed, that sort of thing. Another question that came in is, what is the proper way to deduct uniforms? It depends on what state you are in. Some states don't allow for uniform deductions whatsoever. But you need to have a separate signed uniform deduction authorization agreement, as previously mentioned. In that agreement, it needs to say the total amount, how often this amount is coming out, what happens if they fail to return the uniforms, because some states will not allow you to deduct unreturned uniforms, company equipment, et cetera, from federal pay. So you need to have that separate signed authorization there. Okay, now let's move over to the chat feature. A good question that came in, can you discuss regulations on comp time for exempt employees? Okay, well, again, private sector is not permitted to use comp time. So if we're talking about comp time only deals with people that are eligible to earn and be paid overtime. If I have an exempt employee, they're not paid overtime. So I think what you're asking is flex time for exempt employees. And this is why terminology matters, because comp time does not apply to private sector. Comp time is, again, as I gave the example, I'm not going to pay you the overtime that you're entitled to, but I'm going to give it to you in the form of like PTO hours. Okay, so if I have an exempt employee, it doesn't matter however many hours that they work in that week. They're not eligible for overtime, period. So if we're referencing flex time, remember that exempt employee is guaranteed that salary. So if, let's say, I'm supposed to work 40 hours a week as a full-time employee, but I left early to go to my kids' holiday program, and I worked late Monday night, so I dipped out a little early on Wednesday and left at 4. You can take, per your policy, any time available to them from their PTO, vacation, or sick leave to make them whole for that week. Or you can just let them keep their hours and pay them the guaranteed salary. But comp time does not apply to exempt employees. I already addressed the proper way to deduct uniforms. Question is, are 501c3 nonprofit organizations considered private sector? Yes, they are. Public sector would only be considered state and federal government. Okay. Good questions there. Are there any other questions about wage and hour audits? Oh, wait, coming in. Feel free to use that chat feature. Is private sector the same as household employees? It could be, depending on the industry in which you are in. We often see household members working as a primary caregiver, doing home health type work. It's still technically considered private sector. As previously mentioned, yes, the slides will be provided to you all, and Lauren will send those out subsequent our time today. So you will get a copy of the slides. If you have any follow-up questions or additional needs, if you are a Bankers client and you are enrolled in the Bankers Access through SESCO, you are more than welcome to reach out. My contact information is on the screen. If you are not currently enrolled in that program through Bankers, please reach out to your individual account manager and they can get you enrolled in that if you are not already a SESCO individual client. Okay. With that being said, Lauren, I'm going to turn it back over to you.
Thank you, Jamie. I will share the recording and the slide deck from the webinar shortly with everyone. But thank you so much for joining and have a wonderful day and happy holidays.